Good afternoon and welcome to this month's HR Advanced webinar on parental leave. I'm Alison Williams, Managing Editor at HR Advanced, and with me today is our own IR expert, Paul Munro. Good to see you as always, Paul.
Hi everybody.
Okay, so today Paul is going to answer some of the most common questions we receive on the subject of parental leave, and they're real questions from real people. So just to let you know, our webinars are designed to provide you with a quick grab of information during your lunch break. This webinar will hopefully take only about 30 minutes of your time, but do please bear with us as we go a little bit longer. Now, while we're not able to answer questions during the webinar, please feel free to submit any questions you have on a feedback form, which will appear at the screen at the end of the webinar, and we'll tackle them either directly or as future Q&As on HR Advanced. Now, before we start, I'd like to get some idea of your knowledge of parental leave issues. On your screen now, you should see a poll question, so please take a few minutes to give us your assessment. That should be coming up shortly. Okay, thank you for that. So let's get started. Just moving along. Okay, the first question is about the early return from parental leave. Here's the scenario. We have an employee who's been absent on unpaid parental leave since October and with an expected to return date in October later this year. And the employee has contacted the company stating she wishes to return to work earlier due to financial stress. The company has hired a replacement employee, indicating at that the replacement's interview that the position was a 12-month replacement while the incumbent employee was taking maternity leave. And while we understand there is a guarantee of a return to work for the employee, if she is allowed to return to work before the agreed return date, the company would then have to terminate the replacement employee, and that seems unfair. So in this circumstance, does the employee have the right to return to work from unpaid parental leave earlier than the agreed period of leave when the leave was taken?
Well, actually, the Fair Work Act doesn't give a unilateral right to the employee to return to work earlier than originally agreed between the employer and the employee. In this case, if the employee wishes to return to work from parental leave early, this can only be done with the employer's agreement. So the employer would need to discuss the matter with the replacement employee before coming to a concluded view, taking into account the terms of the replacement employee's contract of employment. That's one of the reasons I suspect that the Act doesn't make provision about giving the employee the right to return early, because usually there is a replacement employee involved. Obviously, if the company is either using a labour hire fill or is managing without the employee, then I guess agreeing to their earlier return to parental leave shouldn't pose any particular problems. The only time that the employer can direct an employee to return earlier is if the person is no longer with the responsibility of the care of the child. So this can be done by the employer giving 4 weeks written notice to the employee. That's where the employer can direct an employee to return to work earlier. So I guess there's two scenarios there in that particular situation. The employee has a right under the Act to extend parental leave once by giving 4 weeks notice, but that's an extension. So once again, if there's a replacement employee involved, then an extension of that may not necessarily be of a major inconvenience to the replacement employee either. But the Act certainly does give the right of the employee to extend once, but the Act does not give the employee the right to come back earlier than what was agreed to prior to the person going on parental leave. So that's the bottom line, really, is that the employee doesn't have a unilateral right to demand an earlier return to work from parental leave. It's only permitted with the employer's agreement.
Okay, that answers that one. Let's go to number 2. Okay, so here's the scenario. The employer has an employee who will be taking a period of unpaid parental leave and has provided the company with dates relating to keeping in touch days. However, the selected times and dates do not suit the business, and the employer generally brings in employees who are on parental leave for their keeping in touch days for training purposes, not just at the whim of the employee. So can the employer refuse an employee's request for keeping in touch days?
Well, I guess similar to the previous question, the keeping in touch days is something that is not mandatory. The Act allows for 10 each year. So, for example, if someone is on 2 years parental leave, which is possible with the permission of the employer, then it's 10 days per year, up to 10 days per year. But I guess not a lot of employers would seem to be aware that there's such a thing as a keeping in touch day, and it's not something that seems to be referred all that much to in a lot of literature. But once again, it's not mandatory, and the employer and the employee would need to negotiate, for want of a better description, the rationale behind when these keeping up days should be taken. The consent for the keeping in touch day is on both. In other words, it's mutual consent on the agreed time and day and dates for keeping in touch days. So it's not, the employer doesn't have the right to demand that somebody attend a keeping in touch day, nor does the employee have the right to insist on a keeping in touch day. Usually, most employers use them for keeping the employee up to date on various matters, particularly if there's changes in, depending on their job, if there's changes in software and the like, or organisational change as well, where a person may very well be reporting to a different person because of the management restructure. These are the sorts of things that that probably would be useful for a keeping in touch day. The thing to bear in mind with a keeping in touch day is that it's paid. In other words, for whatever time the person is at work, be it for an hour or whatever, the taking of the keeping in touch days is not individual days. It can be part of a day, can be separate days, can be several days at a time, or the whole 10 days could be taken in one continuous period. The other thing to bear in mind is the keeping in touch day does not affect the person's parental leave as such. It doesn't extend it, it doesn't shorten it. It has no effect on the actual agreed period of parental leave. And the Ombudsman, for example, talks about suitable activities on a keeping in touch day, and to include participating in planning meetings, performing on-the-job training, performing work to become familiar with the workplace of the employee's role before returning to work. So that's the sort of circumstances that that the employer probably should be looking at to raise with keeping in touch days, and maybe give as much warning as possible to the employee, although there's no specific provision in the Act about the amount of notice as such that's required. But it's something that the more notice to be given about a keeping in touch day, the better, so that the employer would be able to organise their circumstances so that you would be able to get this mutual consent to the taking of the day. So the bottom line is, so that the timing and the taking of keeping in touch days is subject to mutual agreement between the employer and the employee, so neither party can demand that a particular day be observed as a keeping in touch day.
Okay, thanks, Paul. Moving now to our third question. Okay, here is the scenario. Our company has an employee who is expected to give birth next year and has requested 1 month's unpaid parental leave. And this is the first time in our experience that an employee has not requested 12 months unpaid parental leave. So while the legislation appears to prescribe a maximum period of leave, there does not seem to be a minimum prescribed period. So here's the question: can an employee request just 1 month's unpaid parental leave?
Well, if a pregnant employee continues to work during the 6 weeks before the expected date of birth, the employer can request the employee to provide a medical certificate stating that she's fit to work. The period of that comes out of the period of unpaid parental leave. Where the employee has, as I mentioned before, where the employee ceases to have responsibility for the care of the child, the employer may give the employee written notice requiring the employee to return to work on a specified day, which must be at least 4 weeks after the notice is given to the employee. But if the leave is birth related, so in other words, if such as in this case, it relates to pregnancy who was given birth, it's not earlier than 6 weeks after the date of birth of the child. So in that sense, there is a minimum period involved with birth-related leave. With respect to that, parental leave also covers paternity leave and adoption leave as well. But this is birth-related leave with respect to a female employee. So the minimum period there is 6 weeks. The other minimum period is parents can take a specific period of time at the same time. It's a concurrent leave that applies to both parents who are employees who plan to take parental leave. So each period must be no shorter than 2 weeks unless the employer agrees otherwise. So it's recommended that the employer request the employer to produce medical certificate also, because the clock on a lot of these things starts ticking from the time the person actually goes on parental leave as well. So the bottom line in that respect is that it's 6 weeks if it's in this particular circumstance because it's a birth-related leave. There's also 2 weeks if it's the spouse with respect to concurrent unpaid parental leave.
Moving on. Now to our next question. Number 4 of 6. We're getting there. Okay, in this case, the scenario goes as follows. An employee is due to commence unpaid parental leave in the next few weeks. The employee's immediate manager has raised concerns about the employee's health, mainly due to the number of absences from work as a consequence of her suffering a pregnancy-related illness. The employee has got enough paid personal carers leave to cover their absences from work, and the company has offered her the choice of taking parental leave early, but she has declined that offer. And apparently her decision was affected by financial considerations. Now, the employer's concerned with this situation are twofold. Firstly, they're concerned the employee is affecting their personal health by continuing to work. And secondly, the company has a duty of care to the employee under workplace health and safety legislation. So the question is, can the employer direct the employee to take the unpaid parental leave in this particular circumstance?
Well, the Act allows the employer to send somebody on maternity leave under certain circumstances. There is a mechanism within the Act that would allow the employer to send an employee on parental leave in that circumstance. And this is the period during the 6 weeks before the expected date of birth. The employer can request the employee provide a medical certificate which states that the employee is fit for work. So then that's the first step in the mechanism. The employer may require the employee to take a period of unpaid parental leave as soon as possible if the employee fails to provide the requested medical certificate within 7 days of the request. So the employee's got a week. And this, once again, what starts this mechanism is that the employer asks for the medical certificate from the employee. That's what generates this mechanism. So the employee then has 7 days from the day of that request from the employer to provide a medical certificate. If they fail to do that, or that medical certificate states that they are unfit for work, then the employer can direct the employee to take unpaid parental leave. The amount of the directed leave is deducted from the employer's approved period of unpaid parental leave. So if the employee has applied for 12 months and this happens, say, a month before the expected date of birth, then it would be, in fact, then the period of unpaid parental leave would be 11 months after the date of birth if the person's already taken 1 month prior to the expected date of birth. So I guess the other scenario is what happens if the employee is fit for work, if the medical certificate does state that. Well, if it does state that the person's fit for work in their current position, the employer cannot direct the employee to take unpaid parental leave. So in other words, the employer is not the medical practitioner in this case. The employer has to be guided by the opinion of the person's general practitioner or specialist in this particular case. So the employer can't override that by using the mechanism in the Act. The employer needs to be guided by whatever the medical certificate says. So if the medical certificate says the person is fit to work in that job, then the employer can't override that. So I guess the bottom line on that one is that the employer can't direct the employer to take unpaid parental leave except during the 6 weeks prior to the expected date of birth, and where the medical certificate isn't produced, or if the medical certificate states that the employee isn't fit for work in that position.
Thanks for clearing that up, Paul. Question 5. Okay. The company has decided to make a number of positions redundant at the end of the financial year. The affected employees have been consulted and offered post-employment assistance. And in discussions with the employees, it was decided that employment will continue until 30 June, and then they'll be paid out the equivalent period in lieu of notice. Now, one of the affected employee has been employed by the company for over 5 years, but she took 12 months unpaid parental leave several years ago. The appropriate period of notice or payment in lieu of notice is based on her years of continuous service with the employer. So in this case, that's 4 years. The Fair Work Act appears to provide that a period of unpaid leave does not count as service for the purposes of the National Employment Standard. So the employer's saying their understanding that the employee's absence on unpaid parental leave would therefore not count as service. And the question they have is, does that mean that the company is required to pay 3 weeks pay in lieu of notice based on 4 years continuous service, or are they supposed to pay based on some other period of service?
Well, it's one of the quirks of the Fair Work Act that parental leave is actually an exception with respect to notice of termination of employment. The section in the Act, which section 22, it provides a different definition for service with respect to notice of termination. The only absence that is excluded from service when trying to calculate the amount of notice required to be given by the employer when terminating somebody is unauthorised absence, which probably the most common circumstance there would be industrial action engaged by the employees, or other absences where they're contrary from to the direction of the employer. So, in other words, an unlawful absence of some sort. So it's one of those quirky things. The other thing to bear in mind too is that if the person's covered by an award, the amount of notice necessary to be given by the employee when resigning is usually makes reference to the National Employment Standard. So an employee couldn't argue then either, I suspect, that they have to give a lesser period of notice than is required under the Fair Work Act. They would be required to give the same amount of notice and as when resigning as the employer is required to do when terminating somebody. The implication there is, or the consequence of that is, that if an employee, in a lot of awards, if an employee doesn't give the required notice, they can forfeit monies because they haven't given proper notice. In this case, they could probably forfeit a week's pay from all monies due on termination of employment. So employees have also got to be mindful of the fact that they have to give proper notice as much as the employer, if they're covered by an award. If they're award or agreement free, such as management people, then that situation doesn't apply. So I guess the bottom line here is that it does count as service, even though for the purposes of calculating annual leave and accrual of annual leave and personal carers leave, unpaid parental leave is not included as service, but for the purposes of determining how much notice of termination is required to be given by the company to the employee, it is counted.
Okay, and that settles it. Our last question. This is about redundancy during parental leave. So our scenario is our company will be making a number of positions redundant at the end of June. The positions are all in sales and marketing and have been selected on a number of specific criteria. An employee currently employed in one of these positions is absent on unpaid parental leave. The employees will be paid the appropriate amount of redundancy pay and payment in lieu of notice on termination. And our question relates to payment in lieu of notice with respect to that particular employee who's absent on leave, on parental leave. So as she's on unpaid leave, is she entitled to payment of her ordinary wage for the equivalent period of notice, or is there no payment for the period of notice because she's absent on unpaid leave?
Well, a number of issues relate to someone who's being made redundant during parental leave. Generally, the question is, can it be done? The guarantee of return to work is something that certainly the Act provides for. In other words, the employee who proceeds on parental leave has protection under the Act, the guarantee of the job or a job of similar status and remuneration and responsibility. Redundancy or the general protection doesn't protect from redundancy as such. The second question really relates to whether or not the person has been appropriately selected. It's been a number of matters. In fact, there was one the other day that was reported in Workplace Info, the sister publication, regarding a woman who was terminated because she was pregnant. It was an unlawful termination, not an unfair dismissal. So in other words, it was based on discriminatory reasons. It was clearly the case there that the employee was dismissed simply because they were absent because they were on maternity leave. So if, for example, the company applies objective selection criteria, then the person would not be able to be subject to any different treatment. But if the person is obviously selected purely because they are absent on parental leave, then the employer would be, I think, you have serious issues if the employee made a claim, particularly a general protections claim, probably rather than an unfair dismissal claim, because of the discriminatory aspects of that. So as I say, provided it puts pressure on your selection criteria as when you're making people redundant, but that doesn't mean you exclude specifically somebody on parental leave. They are not generally protected. One of the other things that's been raised by friends who are in the legal profession about the guarantee of work is that they wonder, and this hasn't been tested, whether or not, okay, the person's made redundant, that's fine. The selection criteria is objective, that's fine. But when the person was due to return to work, whether or not the guarantee can apply then. In other words, can the employee or the employer, does the employer need to revisit at that point whether or not the person should have their job back? That's something that hasn't been tested before the courts yet, but I know a couple of lawyers that seem keen to want to pursue that particular interpretation of the Act. So at this stage, there's been nothing on that. And certainly as in looking at the initial situation of can somebody be made redundant who is on parental leave, the answer is yes, provided that they've been selected objectively. The other thing is with the notice is that in the ombudsman's of the view, the Fair Work ombudsman's of the view that because the person's absent on unpaid parental leave, you've got to pay them in lieu of notice. It's based on an obscure case, probably now, 10 years ago now, where, and it wasn't even the point in issue in this particular decision, but they seem to be of the view that, okay, the person's on unpaid leave and you might give them, say, 4 weeks notice of termination. The Ombudsman's of the view that you can't give physically 4 weeks notice to say that in 4 weeks' time your employment will be terminated. You would have to pay out the amount in lieu of notice. As I say, that hasn't specifically been tested, but the Ombudsman is basing their interpretation on observations made by a magistrate in a matter 10 years ago. So that's something that you may come up against if you don't pay in lieu of notice in that circumstance. So the bottom line is that it is possible, but just be careful about what selection criteria you use when selecting people for redundancy if they are absent on parental leave. Okay,
I'll remember that, Paul. Thank you. Now, we did have a few questions that were sent in earlier from people who registered. Were you going to be able to answer some of those?
Well, there's some that came in earlier, which I might quickly, they don't look like they require much detail, so I'll try and run through them. There's 4 of them I've got here in front of me. One is about, is it federal law or is it different from state to state? I presume that they're referring to the parental leave provisions. The answer is that the federal law actually applies everywhere. Even these days, it's Western Australia is the odd, or certain employers in Western Australia are the odd people out in terms of coverage under the Fair Work Act. However, because the parental leave provisions, I probably shouldn't go into this too much because it's constitutional law, but the parental leave provisions come from an international convention, an ILO convention, which means it's the power that was used in the Constitution to put that in means that it applies to everybody. So even somebody who's a sole trader or a partnership in Western Australia, who aren't covered by the Fair Work Act, the parental leave provisions under the National Employment Standard would still apply. It's one of those quirky situations under Australian law involving the Constitution and where the law is gained from. In fact, the other law which would apply across the board also is the notice of termination provision that was mentioned before in one of the previous questions. If there is WA law, which there is as a minimum, from memory, there is a minimum Conditions of Employment Act over there, which would apply to people who aren't covered by the Fair Work Act. It's at the very least, the National Employment Standard would need to be met. If the parental leave provision, for example, in the state WA legislation, is of a lesser benefit than the National Employment Standard, the National Employment Standard would override it. The second question is how much notice needs to be given when the person is returning to work. Well, the answer is the Act doesn't really, from memory, the Act doesn't really address that because the date is agreed to prior to the employee actually going on leave. In giving notice and evidence, one of the requirements under the Act is that the employee's got to also identify the period of the parental leave. In other words, what is the expected date of return to work? So most employers that I know would send out a reminder letter just to let the person know. There's no requirement on the employee to provide notice. Like all these things, I guess it's probably best that the employer has something in their system, in their payroll system or their personnel record system, which triggers that to send a notice, say, 4 weeks before the expected date. Because the other thing is that the employee's got up till 4 weeks before the expected date of return to extend the period of the parental leave. So the employer would also want to clarify that as well. Can an employee split their annual leave before and towards the end of their parental leave? Well, annual leave can be taken during parental leave, so the answer is it can be taken at any time. So it doesn't have to be continuous from the date of birth of the child. The person can claim or make a request for annual leave at any time during the period of the parental leave. And the last question I've got here is it's about to do with the government-funded portion. In other words, this must be the government-paid parental leave scheme, which the employer is the paymaster, but not the payer as such. So the solution to allow staff to receive the government-funded portion while enabling us to top it up. I don't see any issue with the employer being able to top. Well, there's nothing that would prevent the employer from topping up from the government-paid parental leave amount to whatever the employee's ordinary rate of pay is. The thing to bear in mind is that there was a case some years ago, not on this point, once again, another one of these cases which has wider ramifications or potentially has wider ramifications. Once the employer starts paying the employee something during the period of parental leave, it would be viewed more than likely as paid leave, which means the people are accruing annual leave and possibly, and certainly personal carers leave and possibly long service leave as well under the various state and territory legislation. So in coming to that arrangement, certainly there's nothing to stop the employer from doing so. However, be mindful of the fact that the person more than likely, and particularly if someone is going on 12 months, well, then someone may very well have an entitlement to an additional 4 weeks annual leave and personal care and 2 weeks personal carers leave at the end of the 12 months. So, whereas if they weren't paid the top up, that wouldn't happen because the Act is quite specific about annual leave and personal carers leave not accruing during unpaid parental leave. So hopefully that clarifies those 4 questions.
Oh, Paul, thank you so much. As usual, you've clarified these very complicated matters. So next we go to a poll. We're just interested in how informative you found today's webinar, and your answers will help us to continue to refine and improve future webinars. So once it comes up on your screen, please just do take a few seconds to complete it for us. Thank you. Happening anytime soon. Okay, thank you so much. Okay, well, we hope you have found today's session useful. Please feel free to drop us a line at customer service, that's all one word, at hradvance.com.au if you have any follow-up questions. And make sure you log on to HR Advance for practical management of your HR work. If you want to revisit today's presentation, an archive will be published on our YouTube channel to watch and listen to at your leisure. The URL will be included in our follow-up email. The subject of our next HR Advance will be performance management, so keep an eye on your newsletters for more details. Thank you very much for listening.
Thanks, everyone.